Legal Aspects of Information Governance. I'm Dr. Mary Cecil. Since 1938, the Federal Rules of Civil Procedure, FRCP, have governed the discovery of evidence in lawsuits and other civil cases. In law, discovery is an early phase of civil litigation where plaintiffs and defendants investigate and exchange evidence and testimony to better understand the facts of a case and to make early determination of the strengths of arguments on either side. Each side must produce evidence requested by the other side to show the court why it's unreasonable to produce the information. The FRCP applies to U.S. district courts, which are the trial courts of the federal court system. The district courts have jurisdiction to hear nearly all categories of federal cases, including civil and criminal matters. Legal functions are the most important area of information governance impact. After years of applying traditional paper-based discovery rules to e-discovery, amendments to the FRCP were made to accommodate the modern practice of discovery of electronically stored information. Electronic information is any information that is created or stored in electronic format. The goal of the 2006 FRCP amendments were to recognize the importance of electronically stored information and to respond to the increasingly prohibitive costs of document review and protection of privileged documents. These amendments enforce the importance of information governance policies, processes, and controls in the handling of electronic documents. Organizations must produce requested electronic documents reasonably quickly, and the failure to do so or failure to do so within the prescribed time frame can result in sanctions. This requirement dictates that organizations put in place information governance policies and procedures to be able to produce the electronic documents accurately and in a timely fashion. All types of litigation are covered under the FRCP, and all types of e-documents, most especially email, are included, which can be created, accessed, or stored in a wide variety of methods and on a wide variety of devices beyond just hard drives. The FRCP applied to electronic documents held on all types of storage and communication devices: thumb drives, CDs, DVDs, smartphones, tablets, personal digital assistants, personal computers, servers, zip drives, floppy drives, backup tapes, and other storage mediums. Electronic document content can include information from emails, reports, blogs, social media posts, voicemails, wikis, websites, word processing documents, spreadsheets. Includes the metadata associated with the content itself, which provides descriptive information about the electronic documents. Some of the key points of FRCP. FRCP 1 covers the scope and the purpose. This rule is to secure the just, speedy, inexpensive determination of actions. The discovery effort and responses should be executed in a timely manner. FRCP 16 regarding pretrial conferences, scheduling, and management. This rule provides guidelines for preparing for and managing the e-discovery process. The court expects IT and network literacy on both sides so that pretrial conferences regarding discoverable evidence are productive. FRCP 26 regarding duty to disclose, general provisions governing discovery. This rule protects litigants from costly and burdensome discovery requests. FRCP 26 also requires that you make initial discoveries no later than 2 weeks after meet and confer, unless there's an objection or another time is stipulated. It also introduced the concept of not reasonably accessible. The concept of not reasonably accessible means that shifting the cost of accessing non-reasonably accessible goes to the one requesting the document. It gives the court a clear procedure for settling claims when you hand over e-documents to the requesting party that you shouldn't have. There's also a meet and confer rule requiring all policies to meet within 99 days of the lawsuit's filing and at least 21 days before a scheduled conference. An attorney must sign every e-discovery request, response, or objection. FRCP 33, interrogations to parties. This rule provides the definition of business e-records that are discoverable and the right to opposing parties to request and access them. FRCP FRCP 34, producing documents, electronically stored information, intangible things, or entering onto land for inspection and other purposes. In disputes over document production, this rule outlines ways to resolve and move forward. It specifically addressed the format for requests and requires that e-records be accessible without undue difficulty, meaning that the records must be organized and identifiable. The requesting party chooses the preferred format, which usually means native files, which also should include metadata. The key point is that electronic files must be accessible, readable, and in a standard format. FRCP 37. It's known as the Safe Harbor Rule. In principle, it keeps the court from imposing sanctions when e-documents are damaged or lost through routine good faith operations. Although this has proven to be a high standard to meet, the rule underscores the need for a legally defensible document management program under the umbrella of clear information governance policies. There have been some landmark e-discovery cases. Zuba Lake versus UBS Warburg. This was a landmark case, an employment discrimination case where the plaintiff, Laura Zuba Lake, sought access to email messages involving or naming her. Although UPS produced over 100 pages of evidence, it was shown that employees intentionally deleted some relevant email messages. The plaintiff requested copies of email from backup tapes, and the defendants refused to provide them, claiming it would be too expensive and burdensome to do so. The judge ruled that UBS had not taken proper care in preserving the email evidence, and the judge ordered an adverse inference, assumption that the evidence was damaging. Ultimately, the jury awarded her over $29 million in total compensation and punitive damages. The court looked at the Rule of 26 of the Federal Rules of Civil Procedure and applied it to the electronic communication at issue. Any electronic data that is accessible as other documentation should have traditional discovery applied. This award was later overturned on appeal. It did make clear that the stakes are huge in e-discovery and preservation. This is a video of the judge in this case making comments about it.
Finally, as a practical matter, you ordered UBS to restore, at its own expense, a sample of 5 backup tapes selected by the plaintiff, produce the requested information from those 5, and then keep track of the costs. The parties could then return to court, and the court would be in a position to weigh the costs and benefits of restoring the remaining backup tapes. Did you think at the time that you were issuing a groundbreaking opinion by holding that responsive information from backup media needed to be produced?
Well, Ken, it's an immodest answer, but I think I knew. I didn't know maybe that it would still be a case taught in law schools 10 years later and that it would be called the basis of today's e-discovery world. I couldn't foresee all of that, but I knew it was groundbreaking because there was no other case to cite. So when I was looking around to how to decide what information was available to be reviewed and produced, I really couldn't find anything that said whether inaccessible sources, that is, that which is not easily available on active systems, needed to be preserved, needed to be searched. I really didn't know. So I sort of worked out a hierarchy, starting with the most accessible, the active data, as you all know, and moving down in 4 and 5 categories to the less accessible, and trying to draw a line and trying to say, we start with the accessible, we move to the inaccessible if needed. That's what I thought was revolutionary at the time. Not so much the focus on backup tapes, although it was a big issue in its day, but the notion of how to do this. How do we do this discovery of electronic information, which I think is quite different than paper. So,
if the facts of Zuba Lake 1 were presented to you again, would you issue the same kind of order, the sample testing of 5 tapes?
The answer is undoubtedly so, if it was presented to me again. But if you mean if it was presented to me today, I would have to give a different answer. Today's a new world. Today I don't expect that the big issue would even be backup tapes. I think there'd be many other issues today, which would be all of the newer sources that have developed in the last 10 years. And we're going to touch on them, I'm sure, in this next hour. but things like text messages and voicemails and social media, there's so much new to talk about. We're sort of, I would say backup tapes are passe to some extent, but the idea of accessible and less accessible and the cost of going to the less accessible is still true today. So the general framework is still there.
Now, the parties did indeed come back after Zuba Lake won.
Another landmark e-discovery case was Coleman Holdings versus Morgan Stanley. Morgan Stanley was ordered to pay over $800 million in damages when they repeatedly failed to produce emails in a timely manner. The judge in this case stated that efforts to hide its emails were evidence of guilt. HCC Holdings versus Flowers. The defendant, Ms. Flowers, is accused in this case of misappropriating trade secrets after she left her company and started a competitive company. The plaintiff, HCC, claims that when the defendant left the company, she took confidential files with her to benefit her new company. She moved 8,000 files and deleted over 8,000 files in her email. A neutral examiner found no evidence that any of the plaintiff file documents were on the personal computer owned by the defendant. However, the examiner did find that the defendant used multiple programs that are not commonly used to cover up spoliation activities. She was found not guilty in this case. Bank of America was filed $10 million by the SEC, the Securities and Exchange Commission. Following an investigation into trading by Bank of America and a former employee, the SEC ordered Bank of America to pay a fine of $10 million after they repeatedly failed to promptly furnish emails and gave misinformation. Qualcomm versus Broadcom, these technology companies. Qualcomm sued its rival Broadcom, claiming infringement on two key patents to technology. Broadcom defended by claiming the patents were invalid because they were developed at the time Qualcomm was participating in an international standard setting group called the Joint Video Team. Qualcomm denied participating in this team. Numerous discovery requests were made for Qualcomm to produce documents related to this defense. Qualcomm repeatedly denied having any such documents consistent with their position that they never participated in this joint video team. After years of discovery, where the party line was consistently upheld by all Qualcomm witnesses and all responses to discovery requests, the case went to trial. After weeks of trial, a Qualcomm witness admitted on cross-examination to having 21 emails related to Qualcomm's participation in the joint video team. So Qualcomm ended up having hidden over 46,000 emails. 6 attorneys were sanctioned, and they were found guilty of patent infringement. Let's look at guidelines for e-discovery planning. First, implement an information governance program. The highest impact area to focus on are the legal processes, particularly e-discovery. From risk assessment to processes, communications, training, controls, and auditing, fully implement information governance to improve and measure compliance capabilities. 2, inventory your electronic documents. File scanning and email archiving software can assist you. You can also want to observe files and data flows by doing a walkthrough, beginning with centralized servers in the server room, moving out to business areas, using a prepared inventory form, interview users to find out the details, and be sure to inventory the electronic documents based on computer systems and applications and draw it out. Create and implement a comprehensive records retention policy and also include an email policy. Include retention schedules for all major electronic documents. This is required since all things are potentially discoverable. Devise a comprehensive retention and disposition policy that's legally defensible. So if your policy is to destroy all email messages that do not have a legal hold after 90 days, and you apply that policy uniformly, you'll be able to defend that practice in court. Also, implement the retention policy reduces your storage burden and costs while cutting the risk of liability that might be buried in obscure email messages. Then, as an extension of your retail policy, implement a legal hold policy that's enforceable, auditable, and legally defensible. Be sure to include all potentially discoverable litigation e-discovery documents. We discuss legal holds. Be sure to cast a wide net when developing retention policy that you can include all relevant electronic records, including email, e-documents, scanned documents, storage disks, backup tapes. Leverage technology. Bolster your e-discovery planning and execution efforts by deploying enabling technologies. Use email archiving, advanced enterprise searching, and predictive coding. Develop and execute your e-discovery plan. You may want to begin from this point forward with new cases and bear in mind that starting small and piloting is usually the best course of action. Information governance and e-discovery work well together. Reduce downstream costs of processing and review by defensively disposing of data according to corporate retention policies. Reduce cost of collection by centralizing collection interface to save time. Keep review costs down by prioritizing documents and assigning to the right level associate. Utilize resources better. Reduce the cost of review by culling information with advanced analytics. Reduce risk of sanctions by managing the process and collection and preservation of potentially responsive information. Have better win rates, optimize decision making, settling cases that can't be won, use advanced analytics, prioritize hot documents, quickly find the necessary information to win cases with advanced searches and prioritize. Use strategic planning. Determine the merits of a matter quickly and decide if it's a winnable case. Quickly route prioritized documents to the right reviewers. Use advanced analytics. Strategic planning for matters based on cost. Quickly determine how much litigation will cost. Use early access to amount of potentially responsive information and prioritize review to make decisions based on the economics of the matter. Use budget optimization. Minimize your litigation budget by only pursuing those winnable cases. Utilize the lowest cost resources possible while putting high cost resources only on the necessary documents. Use e-discovery technologies such as predictive coding. Predictive coding combines human expertise and information technology to facilitate analysis and sorting of documents. Predictive coding software leverages human analysis when experts review a subset of documents to teach the software what to look for, so it can apply the logic to the full set of documents, making the sorting and culling process faster and more accurate than slowly using human review or automated review. Predictive coding uses a blend of several technologies that work in concert. Software that performs machine learning, a type of artificial intelligence, workflow software, which routes documents through a series of work steps, and text analytics software used to perform functions such as searching for keywords. Then using keyword search capabilities or concepts using pattern searching or meaning-based searching, and sifting through and sorting documents into basic groups using filtering technologies based on document content and sampling a portion of documents to find patterns and to review the accuracy of filtering and keyword search functions.
Recomind's Accelerate eDiscovery delivers the most efficient and effective review. Introducing Predictive Coding by Recommind, the patented process for faster, more accurate computer-assisted review. Traditional document review relies on teams of contract attorneys reviewing documents one at a time. Accuracy rates can vary widely, and costs easily escalate. Predictive coding delivers a faster, more accurate review at a lower cost. Predictive coding saves 60 to 90% on review costs, savings that can easily reach millions of dollars per case. In addition, predictive coding provides a more accurate and more defensible outcome. Reviewers identify key documents using powerful concept search and dynamic smart filters and then code these documents. Accelerate trains on the coded documents and prioritizes documents for review. Reviewer decisions help train the system to identify additional relevant documents. The process repeats until all relevant documents are identified. Sampling can be done at any point in the review for quality control and quality assurance. The result is a much more efficient review with a higher level of accuracy. Recomind's customers include some of the top companies and law firms in the world. Learn how to accelerate your e-discovery with Recommind. Visit predictivecoding.com.
Another e-discovery technology is technology-assisted review, also known as computer-assisted review. It's not predictive coding, but includes aspects of the nonlinear review process such as culling, clustering, and deduplication.
With today's technology, we are populating more data than ever before. Over 90% of the world's data was generated in the last 2 years alone. Legal document review has been directly impacted by the data boom. As the volume of data grows, so does the cost of review. You need more people. But even with more reviewers, finding your critical information can be difficult in the time required. Court-ordered time restrictions can become unreasonable. Using a traditional method, your reviewers open each document, read it through, and classify it as responsive or not. Reviewers with different understandings of the case may classify documents differently. This could lead to a key document being overlooked. Despite the amount of time and money spent on going through each document, studies show that human accuracy over time is not even that consistent on large data sets. What if, instead of reading every single document, attorneys could review a smaller statistical sampling of the dataset and use machine learning to help organize the rest? This is the goal of technology-assisted review.
So we've looked at the legal aspects of information governance. We looked at the federal rules of civil procedure. We looked at landmark e-discovery cases, and we looked at e-discovery technologies.